Good morning, ladies and gentlemen. First of all, I'd like to introduce my colleague, Wendy Ray, who's Senior Counsel in the Ombudsman's Office. And I'd like to thank you for inviting us here today to explain our approach to the Office of the Ombudsman of Ontario to dealing with complaints. I think, provided in the Bible, it's a very brief outline of the presentation that we intend to make this morning. It is very brief, so I anticipate only 5 or 6 minutes. As you may well be aware, the role of the Ombudsman is to conduct unbiased, objective investigations into complaints about services provided by the government of Ontario. We receive roughly 20,000 complaints a year concerning over 500 different government agencies, including ministries, boards and commissions and agencies. The Ombudsman is an officer of Parliament who reports directly to the legislature through the Speaker of the House. How do we deal with these complaints? Well, our first line of dealing with them is what we call our early resolutions officers. Their job is to assess the complaint, receive it, document it, resolve it if they possibly can. And they have the authority to resolve it if they possibly can. They determine if the complaint is frivolous, if it's vexatious, if it's trivial, if it's malicious, or if it's made in bad faith. And if the complaint cannot be resolved, or if it's dismissed, then it may go to our investigation section, who are responsible for conducting the investigation. The investigation process is fairly complex. It involves assessment of the complaint, a plan as to how we're going to approach it. It involves interviews in the field, review of documentation, then assessing all that evidence and providing a report. At the end of the investigation, if we find there's something that needs recommendations, then we will make those recommendations. It's the only power we have is the power of recommendation. We have no executive authority at all. In a large percentage of our cases, we find no fault and make no recommendations. We also have something that's called the SORT team, which I'm in charge of, which does the major systemic investigations, such as the ones into the Ontario Railway Corporation, MPAC we did last year, and the criminal injuries compensation law. Those are major investigations involving a lot of evidence and a lot of finding the field. The cost, there's no cost either to anybody to come to our office. We don't levy fees, we don't charge anybody to do anything. And that's typical of ombudsmen's offices across the world. We do not anticipate at the moment any significant additional costs arising from the investigation and closed meetings. Of course, we can't see into the future and we can't absolutely say that with certainty. However, if there was significant additional costs, we would go to the provincial government to request additional funding for the business case. We have a very strong infrastructure and administration process. We have it in place. And we believe that we will be able to absorb any extra work into our current infrastructure. What do we do when we receive complaints concerning closed meetings? First of all, we determine whether or not we have jurisdiction from other investigators, from municipalities appointed an investigator. Then we will refer the complaint to that investigator. We will document and confirm the complaint. We'll go through the assessment process I just talked about. We'll determine if we can resolve it informally, if through by making a couple of phone calls, whether it's a matter of education or providing someone with some information we can get the complaint resolved. Or we will determine if it's frivolous, or it's vexatious or trivial, in which case we will close it. If we decide to do a formal investigation, we will notify all the parties involved, and we will provide them with the results of that investigation should the Ombudsman choose to make recommendations. The Ombudsman is not subject to the Freedom of Information Act, so any document we receive, anything we gather during the course of our investigation is not of our own. If the Ombudsman at the conclusion of an investigation finds that a meeting was improperly closed or procedural requirements were contravened, he can report his opinion and reasons to the municipality or the local board and make recommendations to address his concerns. And once that report is provided, then it must be moved forward. In addition, we report annually in our annual report highlighting information from cases that we've dealt with, which would make it happen for cases involving persons. Under the legislation, we have the discretion not to investigate. We don't have to investigate as long as we can. And in those cases, we will identify reasons why we choose not to investigate.
Absolutely.
As I say, we deal with 20,000 cases a year. We don't have a backlog. We've got 32 years of experience of dealing with these type of oversight investigations. Most of them take a few weeks at the very most, depending on the complexity of the case. Some take longer if the fact-finding process is slightly more complex. Should we investigate a closing complaint, we would ask that the municipality involved cooperate with us by providing us with documentation that we may request. But otherwise, that's the only, and making themselves available for interview should that be the case. Should we require an interview? But otherwise, we would be asking for any significant, or we try not to cause any significant disruption of day-to-day business. So to summarise very briefly, we're free, we're independent, we have a proven and credible investigative process that's worked for the last 3 decades, and of course we have the discretion to decide whether or not an investigation is needed. So that's a very brief overview of what we do and how we do it, and we'll be very pleased to answer any questions that that's one of the
Thank you very much for your presentation. I have questions. First, I have Councillor Zimmerman and Councillor Counsel.
Thank you, and good morning, and thank you for being here. 2 questions I have, and first of all, I guess I'm always reluctant to accept the explanation that something is free, because your funding comes from where?
from the council province.
From the province of Ontario.
That's right. We get $9.7 million.
So the taxpayers are actually paying for your services indirectly.
That's correct.
So it's really not free.
Well, as I say, we do not anticipate requesting additional funds to deal with whatever comes through the door as far as open meetings are concerned at this time, but of course we can't really...
Right, but in addition to that, the taxpayers of Ontario are already paying for your service.
That's correct.
I just want everybody to be clear on that, because it's not as if it's an independent body that's being funded. Second of all, I'm curious, and this may be more a question for our solicitor than for our guest from Impact, yeah, you did mention that. Our guest from the Ombudsman Office. But if we're required under the Act to hire an investigator, is the terminology appoint, actually when we're appointing, are we actually doing a contractual arrangement? Or is it the appointment through the municipality, like the regional municipality of Niagara? It's just an appointment, so we're actually engaging the Ombudsman's Office to be our official investigating body. I'm curious about how that would take place, and maybe that's a question the solicitor can answer, but I have a reason for this question, Mr. Chairman.
Can you address it? Yes, please.
We're required to appoint an investigator. We can do that by contract or otherwise. If we don't, then it defaults to the Ombudsman's Office.
So my question would be then, if we appoint by contract, and again, it's just, I'm thinking through the process.
On a point of order, should we not be dealing with the question?
No, that it's coming. It is coming to that.
Yeah, somebody's question here that was for clarification.
It does. It's clarification on this, because my concern would be if the Ombudsman Office was asked to respond to another portion of our function to be investigated by a group of individuals, would they be in a conflict of interest position if they signed on to a contract with us and in fact they needed to be engaged to investigate some other aspect of our municipal function? And that's a concern I would have, because they could be doing social services, they could be doing something through public works, they could be doing something through public health, through the ambulance. So that would be my question.
That thing would be to the Ombudsman's representatives.
The Municipal Act and these amendments provide us with the authority only to look at municipal open or closed meeting complaints. So it's limited to that.
Wendy, I guess my concern would be, I understand that, but if you were seconded through the complaint process by, not seconded, but the citizens did come to you en masse for an ambulance dispatch complaint, but you're contracted to the region of Niagara for the in-camera sessions, would one section of your legal department have to declare a conflict because you're working for us? I'm looking under the terms of law.
No, one of the things, first of all, we would not, a group of complainants can come to us about sewage, any issue like that. We would not have the authority to look at it. We wouldn't have the jurisdiction to look at it. So we wouldn't be looking at it. But we do get complaints. Let me give you an example. We investigate the Ontario Human Rights Commission. We can also have a complaint brought against us, a human rights complaint brought against us. And we have to deal with those kinds of issues, well, not all the time, but in the course of business, we do deal with those. And there are different ways when there are potential conflicts of interest, who gets to see them, how you deal with things. However, in this particular case, one of the things that, and this has come out in the media, and we're not sure where it comes from, we are strictly limited when it comes to municipalities to only looking at those closed meetings.
If I might just take one clarification. We're not going to contract with the Ombudsman's office.
Why did you use that word?
The only contract being contemplated is the one with AMO or LAS. So our mandate under the statute is if we don't appoint an investigator of our own, either appointed directly or a contractual arrangement as is contemplated with AMO, the default is the Ombudsman's office. So they don't work for us. They respond to a complaint from an individual citizen or some other body.
Yeah, thank you very much. I have next speakers list. Councillors Castleman, Badaway, Puddock, and Davey.
Thank you, Mr. Chair. Two questions. I noticed under the information you've given us that we receive around 20,000 complaints a year. Is that correct? I'm just wondering that if there's some influx of complaints with regard to this matter, how quickly can this be handled?
Very quickly, we've already set up internally. We have an ERI, or early resolution officer, the person who takes complaints, who's assigned to deal with these complaints. We have an investigator who's been trained, and we have an assistant manager. We're a fairly large office. We've got 86 people. We've got a budget of $9.7 million. So we have a lot of flexibility internally to juggle resources, to move people as complaints come in, to take resources away from one area to the next. And I guess it all depends on the number of complaints that come in. We're all waiting to see what happens.
There's nothing predetermined in Mr. Merritt's mind with regard to municipal closed meetings. I mean, this is something that it's not kind of out there to prove a point or anything like that. So I do remember reading something about some statements that have been.
As the clerk said, the law makes us the default investigator unless you guys choose somewhere else. We're just here to explain what we would do if you choose not to choose something. So there's no impact.
And I'm going to ask you, Heather, I guess I'm wondering how many regions have taken on LAS and how many you defaulted and you will be representing.
The latest figures are LAS is 112 as of January the 3rd.
There's not.
112
This time.
municipalities. I think those who publicly say that they will use us is somewhere around 20.
Yeah, there are some municipalities who have actually passed bylaws appointing us, even though they don't have to under the law. But in numbers, there's about 245 that at this point it looks like will either have appointed us or are using our office as the default.
So I think you have to add more people to your 86.
One of the things we have done, because we've known about this for the last year, we've actually trained all our staff on the whole closed meetings and on the legislation. And we have like we prepared all our manuals and guidebooks. So all our staff have actually been trained on how to look at these kinds of issues. One of the things that Gareth was saying is the way our office is set up. For example, when we did the impact investigation, we got about 4,000 complaints in a matter of a few weeks, and that's a large number. But because of the way our office is set up, we can actually move staff around. So if there's an influx of complaints for some reason that need to be dealt with through intake, we just put more of our resources there. And the office is one of the things that Mr. Moran did when he came to this office was to make sure that we have the capacity to respond to things in a timely fashion.
If your office found that there was a certain particular procedure that was happening across the board, would Mr. Moran write a report or anything like that to state that, in your findings over the past, let's say, 2 years or whatever, X number of issues seem to be arising about this one factor?
One of the things that we do is we have an annual report where we summarize and highlight information over the last year, and we talk about trends, and we set out sort of our 10 top complaints or our 20 top complaints. We also...
So this could be included in that?
Yes, if you take a look at our annual report, you see that we currently do things like that.
Okay.
We also, one of the things with the closed meeting complaints, because of the way the legislation is written, once the Ombudsman does make a report, there's recommendations. And they are just recommendations. So whether they're implemented or not, that's going to be up to the municipality. But those become public complaints. And so they will probably, I don't know all of them or how many there are, but information like that will be posted on our website.
Okay. Thank you very much. Thank you.
I have Councillors Badaway, Beatty, Burrows, and Green.
Thank you, Mr. Chairman. My first question, and I thank you for being here, by the way. It's wonderful for you guys to come on out and explain to us how finally there's going to be some teeth added to something, for lack of a better statement, to a toothless tiger. My question may go the other way, in terms of some of the questions that are going to be asked today. Is there the possibility of having complaints brought to your attention for councils coming out in the open too much? And those complaints may in fact be developers, people that are within negotiations with municipalities, people that may have private information that they may not want out in the public, that maybe they had thought may be for the Privacy Act brought on camera, but wasn't, it was brought up in the open session. What in fact happens if in fact you get a complaint from an individual, corporation, business, etc., for something that's been brought up in the open that they would have otherwise expected to be in camera?
At this point, our authority under the legislation, I think, is pretty clear, and it doesn't address those kinds of issues where the Municipal Freedom of Information and Protection Act might cover those kinds of issues. So that might be a referral that would be given in those kinds of particular cases.
And it leads to my second question. I think Judy was sort of getting to this. I don't want to put words in her mouth, but I think she was in fact other concerns that do arise from both constituents and councillors. You mentioned to Councillor Zimmerman that your mandate is just closed-door meetings. And there have been concerns brought to my attention within my little part of the world about enforcing, for example, rules under the Municipal Act. Now, you are a creature of the Speaker of the Office from the legislature. We're a creature, obviously, of the legislature as well. And it might be an unfair question to you because it may not be part of your mandate. From what I'm hearing with your answer with Deb, it's not. But who would we go to if we have complaints about not only us, but citizens, if in fact we suspect there's certain rules or regulations on the Municipal Act that are not being followed, certain codes of conduct by either staff or councillors that are not being followed. And then, of course, past that, under Section 216 of the Municipal Act, it does somewhat discourage any repercussions from happening. And again, a toothless tiger. So what I'm getting at is that who do we go to when we have those problems? We're between a rock and a hard place when we have codes of conduct and things of that nature that are there, but they're just toothless. So who do we then go to?
Well, under the Municipal Act, they did include the opportunity to appoint ombudsman at the municipal level. But that's something that a municipality would have to decide whether they are going to be doing that. But from our point, our office, say somebody brought a complaint to us about that and there wasn't any, I think that, the referral would likely be to the ministry so that they can hear about these things.
And the ministry stands back.
But one of the things that, if you do look at our annual report, we do collect stats on all our complaints that come in, whether they're within our authority or not, because it's work. It takes time for our office, and that's what we're reporting on in our annual report. So if you look at our last annual report, you'll see that we have already received a number of municipal complaints, and we have for the last 30 years. So we do generally talk about those kinds of numbers, but we wouldn't have the time to catch them.
So it would be fair to say that if I was in the Speaker's office and let him know of those concerns, that in fact he may in fact either delegate to you and or other areas, or would it be the ministry?
It wouldn't be the Speaker's office. It would have to be something that is done through legislation.
Thank you.
Councillor Pike?
I'm glad to see there's a few others that have got their hand up and can't hear, but I don't know if you're asked this question. Where would the Finance Minister of Ontario fit in? Could I put in a complaint to you about him having a closed door meeting in Niagara Falls? And the reason given was that everybody can speak up and talk to him. Could I use that, the same analogy here, that go to Mr. Jones and say, I want to talk to the council about something, and I want them to speak up here, just a second.
You can certainly make a complaint about the administration of administrative findings
To our office.
to our office, but
And about the minister.
and about those.
I'm just wondering, because, and I'm not criticizing the minister or the government, I'm criticizing the process of everybody staying open, and it's the first time that I've been around that I knew there was a minister that was going to have a meeting and couldn't sit at the back room. So we'll just see what happens with that, because that kind of ticked me off. The second question is clarification, if I may, Mr. Chairman. Maybe Mr. Bergman or Mr. Trojan could answer this. And it's in regard to this being free. I agree with Councillor Zimmerman, nothing is free, and I appreciate that you're paid by government. But we pay a membership fee to AMO, or in this case to LAS, and then over and above that, do I understand that if we took them on, that there's a charge, what was $1,100, is that true?
It's the next presentation.
That's next. Perhaps Mr. Pike will wait till the next delegation.
Yeah, so the point is, my point is, if there is a charge, then we're paying it twice. I'll ask the question.
Next up, I have Councillors Beatty, Burrows, and Queen.
First of all, welcome to Niagara. Come back often on complaints. I heard you say with regard to a formal complaint, investigation, and then a report is filed and recommendations must then be made public. The question is, the first part of it is, what about vexatious or frivolous complaints? Where, when, and who makes that public that this has been dismissed?
Well, first of all, the majority, just so that you understand the numbers, like the majority of complaints don't go to formal investigations. Very few actually do, because most of the time complaints are resolved way before. With respect to frivolous and vexatious complaints, our our legislation is actually even broader than that. We have the ability to say, in the circumstances of the case, we're not going to continue to investigate. So it's not just frivolous vexatious, it's not made in good faith, it's really quite broad. Depending on a lot of those cases, when Gareth was saying we do an investigation, usually within a few weeks, they're done. But the majority of our complaints are actually dealt with in a few days because we don't go to the formal investigation. So that's where the majority of frivolous vexatious complaints are actually dealt with early on. However, sometimes you need to get into collecting more information before you can make that determination. Not necessarily actually going to the investigation, but we can also make that determination during a formal investigation as well.
I understand that point. The question, though, specifically is who communicates that the issue has been dealt with and resolved? Your office, or is it?
In some cases, you won't even hear about it, because if we get the complaint and on its face there's nothing there, the municipality might not even be contacted. In other cases, you might be contacted for some information. We do keep track of the number of complaints, and they will be in our annual report, just like they are for all the different government agencies that we have. So you will get a number like that, and if you are interested, we can always be providing you with that information.
So we, in the public, may not necessarily know how many complaints have been registered, and how many have been dismissed, other than the formal ones.
You'll know that.
You will know that. You'll know that at least on an annual basis. That information is made public.
Moving to the one we talked about, the formal recommendations and so on, and that must be made public.
That must be made public. Under the Municipal Act, it says that the municipality has to make it public. So the municipality makes it public, and once it's public information, we'll put it up on our website as well.
Okay, that answers what I was going to ask. How do we learn from others' mistakes? So access to it that way. And lastly, my question is, if you enter into, in a sense, it's not a contract, but you take on this service for this year, is that for life, or can we reconsider at some future point?
The way the legislation is written, at any point you can make the decision to go with LAS and have some investigator. We are the default. Now, if you pass a bylaw option saying that we are the investigator, then that's the bylaw that's changed. But one of the things that I believe the LAS has said is if we are in the middle of investigation, they wouldn't interfere with that, because under the legislation, we would still, and we would take that position as well, we would still have authority over that particular complaint. And it's the same going back and forth. If you had an investigator appointed and you decided to then use the Ombudsman's office, we would, at that point, that complaint came forward, we would not have been looking at it. So they would.
Councilor Burrows.
Thank you, Mr. Chair, and I believe that my question has been answered, but I'll just get some clarity. A number of speakers have requested information about the learning part of this process. You're saying in an annual report you do summarize all your investigations and that kind of thing. But is there, once this program gets going, is there some ability to summarize specifically to in-camera meetings so that municipalities can learn from decisions that are made, or is it up to us to research through your website?
I think this Ombudsman in particular is very proactive around going out there and communicating his findings to individuals or groups that are impacted by our investigation. So I should imagine that as information becomes available, as we get to learn, as we go through, that he will make that information available to those who are affected by it.
I have Councilors Greenberg, Augustine, Salsi, and Dan.
Thank you, Mr. Chair. I believe my question has been answered as well, but it was, had we decided to go with the Ombudsman and say we were satisfied at some point in time, that we decided to opt out and go with LAS, there is no penalty. No penalty at all. Thank you very much.
Councillor Levesque.
Thank you very much, Mr. Chair. I'm just looking for some clarity, and I certainly appreciate the presentation today. Some clarity between your comments in the presentation today and some of the comments from the Ombudsman when he made a presentation at the Dominion Club on October 31st, 2007 at a topic called transparency or puffery. And if I might quote, Mr. Chair, the Ombudsman, and I've asked the presenters to give some clarity to this. In line paragraph 20, he states, as of January 1st, if any municipal council or committee tries to hold a meeting behind closed doors, the public will be able to make a formal complaint. And if the municipality hasn't appointed an investigator to look into these complaints, the complaints will come to me, the Ombudsman. That's what you've stated this morning. The Ombudsman continues. He says, sounds like a real step forward for the public's right to know, doesn't it? After all, municipal councils are often criticized for holding in-camera meetings. And this is the point I'm looking for clarity on. Just last week, we learned Toronto Council passed a new contract for firefighters in June without the public knowing anything about it. What is implied in that is that a council, i.e. the City of Toronto, could not hold a closed-door meeting about a contract with their employees. And I'm looking for clarity, Mr. Chair, on and also the way that this is phrased in terms of if a municipal council or committee tries to hold a meeting behind closed doors, as if it's not allowed, but hey, you know what, we're going to try to do it. Could you please clarify the situations in which we can, as council, and in a responsible way, hold closed-door meetings?
I'll leave the second part of that question to you. But I'm so reluctant to put myself into the mind of the Ombudsman, A, because I wasn't there, and B, he's not right. As far as the second part of your question is concerned.
Under the Municipal Act, there is a list of the exclusions that the municipality can hold closed meetings, and it states what those situations are, the votes to be taken, and things like that. And those would be the criteria that we would be looking at going forward as of January 1st.
I think members around this table are all familiar with those criteria, those reasons for going in camera. What I'm concerned about is the comments from the Ombudsman, and granted, I'm just taking a little snippet from a 5-page document, his speech, and where it's implying that we cannot do this, and that certainly when the City of Toronto, for instance, is discussing employee negotiations, as we might do in this committee or certainly in council, that we could not go in camera. And the reason for going in camera is to protect, in the case of employees, those employees, or in the case of the corporation, if there's a legal agreement. You know this, and members around this table know this. Perhaps I'm saying it because we're being recorded, but it's to protect the interests of the corporation or the employee. Can you comment further on this in terms of, it appears on the one hand that your presentation today, you fully agree with this, and on the other, the Ombudsman is saying that it's just puffery and that this isn't going to do anything at all.
Again, as you pointed out, it's a snippet from a, as you said, 5-page speech that he was making. What I do know is that the Ombudsman has great respect for the process, has great respect for municipalities, and he's very keen to make sure that the new law that comes into effect works and works for everybody's advantage. Beyond that, I really can't comment much further because
One more question, Mr. Chair, and that is, and maybe the presenters can't answer this. We've been told that the municipality can appoint anyone, somebody from out in the public. We can stop somebody on the street and say, hey, you're the investigator. We can appoint an employee. We can enter into a contract with another body like LAS, and we're going to hear that presentation in a few moments. And the default is the Ombudsman's office. I'm wondering, and again, maybe the presenters can't answer this, Mr. Chair, why the government set it up that the Ombudsman's office is the default. In essence, why the government didn't say, you know what, as of January 1st, 2007, if you want to make a complaint, go to the Ombudsman. Do you have any knowledge about why that occurred?
I certainly don't.
Okay. All right, thank you.
We were contacted by the ministry and presented with the legislation.
Thank you.
We have Councillor Salsi, D'Angela, and then
Thank you, Mr. Chair. As you are aware, I'm not a member of the Corporate Services Committee, but I do appreciate the opportunity to attend this morning and to observe the presentation. And to our presenters, I just have a few questions. Mr. Jones, with respect to the cost and the suggestion that there is no cost, and knowing that you do have 86 people employed at the Ombudsman's office and a budget of $9.7 million, do you anticipate working out an hourly rate as to what the actual cost to the taxpayer might be for your service when you do investigations?
No, we don't approach investigations that way. We have our global budget that's assigned to investigations. We do investigations based on the complaints and type of complaints that come through the door. We don't cost them out on an hourly basis.
So what would happen if you had a great influx, or if you had no complaints with respect to this additional challenge that you've been undertaken, its duty as default investigator? What do you do at the end of the year if you have? Would you have surplus in terms of costs, or do you lay people off, or do you hire more people in the event?
I think we've got the infrastructure in place, we've got a big enough office, we've got a considerable budget that we can juggle and change and move people around and deal with influxes as they arise. We have 20,000 complaints a year. We have no shortage of work with problems and these are available in the budget. Does that answer your question?
Well, I'm just trying to get a handle on the cost that actually would be attributed to the taxpayer. Basically, there's only one taxpayer, as you're all aware.
Sure. There's no extra cost other than what we're getting now. We don't anticipate any extra cost. Save and except we get a massive influx of cases, complex investigations, which we have no reason to anticipate at this moment, but who knows what may happen, at which point we will go to the provincial government with the business case as to why we should receive further funding, and they will make a decision whether or not we get it. What I can say is our costs are far less than $1,250 a day.
Well, we don't really understand that point because we don't know what the cost of your investigators are on per diem. If you want to compare apples to apples, I think we need that figure because we have a private service that's offering a cost at a fixed rate. But you're suggesting to us you could either absorb or go back and ask for more money, depending upon the load that you have experienced in this next year. So there's a cost, obviously. We just like to get our hands on it.
But if we do get an influx we fully anticipate that we'll be able to deal with it within our existing budget. If we do get an influx of cases, we'll look at the type of cases, how long it took to get us, whether we anticipate a further influx in the upcoming years, and we put in the business case budget in the
Okay, it's still an unknown. As I said, we'd like to have a better figure on that. Second question, Mr. Chair, I do have is, where does this process stop in respect of a complainant who files a complaint and let's say a private investigator, private service investigator is hired? If they come after the decision has been made that there's been nothing improper, that they come to the Ombudsman of Ontario and say, I didn't like that decision that investigator reported back to that particular council on, what's your position in that? You start all over again?
No. A, if there was another investigator being appointed, we have no jurisdiction. B, I can't think of a set of circumstances where we would re-investigate somebody else's investigation, even if we have it.
Okay, thank you, Mr. Chair.
Councillor D'Angelo.
Thank you, Mr. Chair. My question's just following up on Councillor Beatty's questions. And I guess my question is, why wouldn't the municipality not be notified of all complaints, even if they're frivolous, vexatious, or not under your scope?
Well, at some point, you will be, but if they're, in terms of turning things over very quickly and there's nothing, the complaint that's coming forward has no impact at all in terms of they're making a complaint about something that there's nothing in the legislation that deals with that. We would close it and give a referral, whatever the issue is. at the end of the year, or if we saw that there were a number of complaints coming in on a particular municipality, we might contact them at that point. But if we needed to get clarification or anything like that, we contact the municipality. Right now, if we get a call, we are contacting, in most cases it's the city clerk, if that's the municipality. Right now, if we get a call, we are contacting, in most cases it's the city clerk, if that's who the municipality has told us to contact, or if they've given us another contact person to get information. And that's how the municipality is getting the information right now.
If we take any kind of substantive step on a complaint, you will work at it, because our goal is to try and get it resolved informally before we have to go to this full investigation stage. And we can't get it resolved informally without dealing with the clerk or dealing with council or dealing with whomever to get that process working. So in essence, you will know about everything except the most trivial or non-relevant cases.
Like complaints, for example, with somebody complaining about sewage. Well, we have no authority to be dealing with that. We're not going to contact you on that. You will see that number. We might provide that number in stat at the end of the year about complaints against municipalities, but that wouldn't be something we would contact you.
See, I sort of disagree with that, because I think as a municipality, there's a reason you should know what's being complained about, because it's a perception that you're not doing a good job, or you're not informing your taxpayers or your ratepayers. So by withholding that information, you're not giving us tools to do a better job. So I think, regardless of what the complaint is, it should be brought to the attention of the municipality as quickly as possible, so they can address that in a fashion to improve and show that municipal government is responsible.
We would always, sorry.
Yes. We would always give a referral back for that person to go back to the municipality.
No, but I think the municipality needs to go directly to you that it's being researched, because it's a nick against your credibility. And municipalities and municipal governments get dinged all the time. Here's a chance to reward a municipality that's doing the right thing, not going in camera under the improper legislative rules, or if they're being dinged on sewage or water, it's because they're not communicating the message properly out there to the taxpayers. So I see this as a tool also for the municipality to become a better communicator with taxpayers, because if it's a frivolous thing, it can be resolved very quickly, but if we don't know about it, we can't fix it. And that's the same message I give to my taxpayers on a daily basis. There's a problem in our municipality. Call our municipality. We can't deal with it unless we know about it.
And that's exactly the message we would give to somebody who called about water or sewer, saying, we can't deal with it, here's your councillor. It's a very strong suggestion.
Yeah, but you should be notifying us. That's the point I'm trying to make. Thank you.
Councilman Ray.
Thank you, Mr. Chairman, and thank you to the presenters for being here today. When this first came to our council, there was a lot of uneasiness, I guess, because of not understanding, one, I think it was referred to earlier, the work of the Ombudsman and to our scope in this area, but also the potential for an influx of complaints. And when I say that, in the municipality, you get complaints on a daily basis or whatever, but there is a cycle, and the complaints seem to increase dramatically the year of an election. For people trying to make headlines, as was pointed out here, they will make accusations or make complaints or whatever as their platform for running, when in fact it may be misinformation. So I think some of the questions you're getting today are similar to the questions from my municipality. How can it be free? One, and you address that, it's not, and it's 400,000 per person. Give or take a little bit, 6 people, 9.7 million, so we go from there. 20,000 complaints. If you're following the rules, and Councillor D'Angelo was mentioning this, or hinting at it, we should know prior to the year end in a general summary, we had 2 complaints about your municipality. Because this has got to be an educational tool for us as well. So they want to have open and transparent government. You're getting complaints, are they legit or no? If they are areas of concern, we won't know about it until the next year possibly when you do your top 10 and say, hey, we had a handful, 5 or 6 complaints from this small municipality about this same kind of issue. Well, if you're not going to let us know each time you get a complaint, whether it's frivolous or not, our town clerk or our city clerk or the regional clerk will not necessarily be able to say, and in a lot of cases, they're the ones that will direct us, whether or not it's a can or should or whether we're going to close session. So there's a few pieces to this that still have an uneasiness around. I think some of the, I won't say whether it's good or bad or indifferent, I think some people signed up for a representative or an investigator because of that fear of, well, what if it hits the fan? In a cycle, your third year is going to be the one where you'll notice an influx and you'll be going for more resources if my thinking is correct. That's 2010. And that's the election year. The next election year. So, having an idea of what kinds of complaints deal with now, this new responsibility, especially in the first year, if there's not a mechanism for us to say, the region of Niagara, we had 2 complaints in the first half of the year, or 2 complaints, last month about your closed meetings. We have a lot more meetings here at the region. We're trying to be aware of it, but Councilor Badaway touched on it as well. The opposite is not going into closed session when you should. And then you're legally liable as well. So we want to do the balance, we want to do it correctly. And if we don't have a feedback mechanism in a short order, at least in the first year or 2, to say, okay, it's still working, our habits are good, then the whole system runs where it doesn't. So
your feedback mechanism for the closed meetings, you will be getting the information that you need out of our office. Sorry. If it's dealing with closed meetings. That's
something other than just a yearly report. It'll be, I like the comment, I think, that you made it, that if you had a complaint, you'd be contacting the clerk in most cases.
Unless the municipality who is using the services of our office has told us to contact
somebody else.
The chief administrator.
Okay, so if that works, then there is a mechanism so we'll at least know we had a complaint.
Yes.
Good, bad, or indifferent. Because you would have to contact our clerk to start with.
We actually sent a letter out in October to all the municipalities asking for information about whether they are going to be using our services or not, and if they are, who the contact person should be. We got a number of responses back. But what we're doing now is every time we do get a complaint, they're starting to come in. If we haven't heard from the municipality, we are contacting the municipality with that information. And we have a pretty sophisticated in-house system so that, we have a list of all 445 municipalities, whether we're, if you know at this time, whether we're the investigator for these cases, who our contact person should be at that municipality. So all that information is available to our staff who actually communicates.
And just following, Mr. Chairman, I think a lot of the angst prior to January 1st had to do with things that were reported in newspapers, comments that may have been made and taken out of context or not. And there's a lot of uncertainty around it. So I'm glad that Councilor Augustine had mentioned that one presentation because it put an uneasy feeling in a lot of municipalities for maybe not a good reason. So you've had some questions today about motives or their scope of responsibility and was it a witch hunt or are the municipalities doing a good job or not. Those kinds of comments, when you're dealing with it at the ground level, are important not to be made by people if you want them to use your services. So that's why I think a lot of uneasiness, and you were in the town of Fort Erie, were almost that exact reason comments that were made and stuff was being reported in the office or others were maybe just in the press. And there's a lot of uncertainty. So I'm glad you're here today and look forward to the next conversation.
Thank you, Mr. Chair. I guess I'm not really here to debate your ability to investigate and report back, but I certainly feel like we've been left with a void after Councillor Salsi's question with regard to cost. There certainly needs to be a cost for us to be able to make a decision here. I think it was very vague in saying we can absorb it. We've got the budget. I guess I'm not buying that. That's like saying there's 3 gas stations on this road and one of them has an unpublished price. Where are you going to go purchase your fuel? Are you going to wait until you get your credit card bill and oh, they charged me $2 a liter because I went to the one that was unpublished? I think in order to truly represent the taxpayers, which we all are, whether it's through the province or the municipal tax, we really need to know what the costs we're facing to make an informed decision on what's going to best suit our taxpayers and tax levy. So I guess I'm coming to you again and asking you, are you going to provide for us the true cost? And understanding that in the 3rd year, as Councillor Bentley said, there may be an influx. So are you talking about more bricks and mortar, more people, more phones, more sophisticated in-house systems, I think was one of the things that we heard of. All those things come with a cost, and we truly need to represent the taxpayers.
I understand your point, sir, but I can't predict what's going to come through the door in the future. As things stand, I can only repeat that we anticipate being able to manage complaints about open meetings within our existing budget. Obviously, we can't make a commitment. We can do that. That's the furthest we can go at this time. 6 months' time, maybe in 3 months' time, we'll know roughly how many complaints we're getting and what's it's costing us to deal with them. At this point, it's constant.
So in 2 or 3 months' time, we may be able to provide a direct cost saying we have added or decreased by this many employees with this office space. Whatever your true costs are. So if we went with another alternative for the next 3 months, there may not even be any investigation. But if we went for 2 or 3 months with another alternative, can you come back to us in 2 or 3 months and say these are our true operating costs on a per
I think we can
basis?
tell you how many complaints we had and how we've been able to manage them.
But that's the closest you'll be able to get to doing this at per unit cost.
I think the Ombudsman's committed to by the end of the year, we'll sit down and discuss what we've got and he'll make a determination as to whether he needs to go to the Speaker of the House to ask for additional funds.
Do you understand my concern going in blindly here? I mean, we've got one product and they're operating as a direct relationship. So we've got another product that says build it and we will come.
I mean, one of the things you have to understand is we're the investigator by default under the legislation. Today, we do not appoint an investigator. We have to do these investigations, which we plan on doing. We could have said, well, we don't, in terms of cost, we need more money, give us more money, and we'll do this job. But at this point, we don't think that we're going to need additional funds, and we want to see the number of come in, their complexity. We haven't hired more staff to deal with this. We haven't increased our complement. When we go for our budget this year, we cannot ask for additional funds, and we're not planning. That is where we stand right now. In terms of how many complaints do actually come in, we won't know, and it will probably take more than 2 or 3 months for us to find that out. Of course, the first week we expected a number of complaints. We did get, but they were closing prior to January 1st. We're not looking investigating. So we can't give you that information. We don't have it. Now, I can tell you our annual report comes out in June every year, and our year end is March 31st. We will have 3 months having this authority over closed meetings that we will be reporting on, and we'll have a much better idea at that time.
So you were mandated to be the default as a sort of catch for all municipalities to be covered. So it's not really in your interest, given your budget and your assumption, that you can cover it with your current staffing complement. It's not really in your interest to go after more business. You prefer us to go find another alternative so you can keep your budget, either laying people off or have people twiddling their thumbs.
It's totally the truth. We're mandated to do it.
I got the impression earlier, I guess, that the Ombudsman really wanted this business. I mean, am I incorrect? You can care less?
Well, it's not that we couldn't care less. He he understands that it's your choice, your decision, your responsibility to decide what you want. If you choose to go with us, or by default, choice, direct choice, then we will happily forward you the rules.
One of the things that is one of the reasons why we're here, and we've been at other meetings as well, is because there is a lot of miscommunication out there in the media. And I know I've been contacted by a number of municipalities who have asked me for specific questions or to do a presentation, and they needed information. The Ombudsman has said when the decision is made on how you want to proceed, that you should, the municipality needs to be armed with that information to make an informed decision.
I guess I'll leave it with I'm looking forward to the 3 months or whenever your June release comes out to find out what a true per diem cost would be, including overhead, bricks and mortar, and staff. I'll leave it at that.
Is there anyone else who hasn't asked questions yet? Councilman Marshall?
Thank you. I'm looking at it a little differently. I understand that you're the default position. I think we have two groups in front of us today that likely want our business. If you don't want our business, that impacts my decision. But I'm assuming that you want the business. Is there anything that you can provide as it relates, notwithstanding the money, but looking at the other, the ALS and what it has to offer? Is there something you can offer us that would suggest to me that the Ombudsman office would be superior? If you have to give the camera, that'd be up to you. But, is there anything you can offer?
Sir, we're not here to compete with LAS or anybody else. We're just here to put out what we do, how we do it, our approach to investigations, our reporting mechanisms, how we try and get things resolved. If you find that's something that you want, then we're happy to oblige. We're happy to oblige and provide that service. If you decide that the LAS or somebody else is a better avenue, then so be it. It's entirely your decision.
Anyone else who hasn't spoken? Okay, I've got a second speakers list. I have Councilor Zuman, Councilman Badaway, and so on.
Well, I'm going to ask a question that I think Councilor Marshall was asking in a different way, because what are the limits of your power? And I'm referencing Section 14.1 of the Act under the function of the Ombudsman. And I think it speaks to what Councilor Badaway was pressing for. You read the section, and I'm not a lawyer, but the section seems to give you a ton of opportunities to look at government administration.
The way what's happened is the Municipal Act.
Yeah, I understand this.
Has basically said some of the authority under the Ombudsman Act applies, but it's limited to the looking at the closed meeting provisions under the Municipal Act.
I realize that, but that doesn't preclude you from using Section 14.1 of the function of the Act to investigate any decision or recommendation made or done by or omitted in the course of the administration of a governmental organization. That's your section.
Yes, but that's the...
Is governmental organization defined?
No, governmental organization for the purposes of the Ombudsman Act, well, government is defined under Section 1, but it's been dealt with by the courts. There's a whole definition to it. But for the purposes of the Municipal Act, that broad section is not applying to us looking at municipal meetings.
No, I'm not talking about, but there's other than municipal meetings, we do other things that just come to council.
We are not given that authority.
You're not given the authority to look at our police, our ambulance. If you've got a group of complainants who come forward, this action doesn't apply. Okay, so the limits of your power then, and the difference between LAS and you, is I understand this, is that you have the authority to subpoena.
Well, they actually have some authorities too. They get the same. The Act is very common with that. I won't get into the whole thing. One of the powers that we do have under our Act that is not set out in the Municipal Act for the investigators, other investigators, is the power of entry. But the bottom line is, it depends on what the municipality puts in their budget when they appoint an investigator.
So, and then my other question would be that you have the power to subpoena individuals, which is different than LAS, as I understand it. And I can understand that question.
Yes.
You have the power of entry, right? You typically do not supply the municipality with the complaint process. I think the educational package is what we're looking for, but you've sort of deferred to say that you will help us through that. The question would be then, if we don't pass a bylaw to appoint you and we default to the ombudsman, what would be the difference?
It depends on how the other people investigate. We have a...
No, you're missing my
in
point.
terms of-
If we don't pass a bylaw to appoint the ombudsman's office, and I think it was touched on, and we automatically default to you, what would be the difference? Would the bylaw be more prescriptive in the rules and the way in which we get to investigate, or are they exactly the same? So I think the question was asked, why did the government of Ontario, in fact, say that the ombudsman would be the default position? And why are we even considering you if we just default to you on an automatic basis? I guess is a question.
That's a question. I know that a number of municipalities have actually appointed us, even though...
But why would they do that?
It's something you have to ask.
Okay. But it doesn't change your power or authorities as the ombudsman's office. Thanks.
Councillors Castleman, Garraway, and Council.
Mr. Chair, good discussion. I don't have any problem. Obviously, your office is extremely competent and good to handle this very well. My concern is the disconnect between your office and the municipality when this happens. And you're saying that it would be a stat in the report, for instance. Let's say there's 100 complaints from Niagara. That seems like a lot, but who knows? And 96 are frivolous, and they're just, dealt with in a couple of days. And 4 are, asked for more information, and maybe nothing actually comes to any fruition to be investigated. But that would be a stat, though, in the report, that there were 100 complaints. And I don't know whether or not that would be actually, you would go through that, and that whole kind of like, I'm concerned that suddenly Peel got 10, and 15 in Durham, and 100 in Niagara, and suddenly the ombudsman saying, we need to do something about Niagara. So I'm just concerned how that is communicated to the taxpayers and the rest of the province.
I think if you look at our annual report, if there's anomalies there, if something needs an explanation, if there's 96 frivolous complaints, there'll be something in the next text explaining it. The annual report isn't just statistics. The annual report is we write, if you look at annual reports, we write prices of what happened in a given field in particular agencies. And now we can't do it for all 500 agencies, boards and commissions we oversee, but we truly try and explain the statistics as best we can. And I know it doesn't deal with your question about 100 complaints, but
I think that's really an important issue when we're sitting here. Certainly, don't feel defensive about having someone come in and look at why we're going into an in-closed meeting. We certainly feel that we have staff and lawyers and so forth to be able to give us that advice. But if this is the way this is going to go, which is fine, then we want to make sure that the correct information goes out to the public. There's so much incorrect information that goes out, and suddenly, this is, blowing up and actually,
But one of the things that I think you've got to understand is we have an infrastructure. I mean, that's what our business is. We only deal with complaints. Right? So when a complaint comes in, and if it's going to be closed as frivolous vexatious or whatever, we have an internal process where we have a manager who reviews the complaint to make sure that it's appropriate. We have discussion meetings on a weekly basis if people aren't sure how to, we've got this whole infrastructure now. At say there's 100 complaints that come up from a municipality, and a municipality wants to sit down and talk about those details of those complaints. I mean, we do that with government agencies.
That's not my real concern. My concern is in your report, how it is reported, that's
Right.
all. And that's it's the perception.
Right, and in terms of formal complaints, sometimes you'll see what's a formal complaint, what isn't. And we make it very clear what those numbers stand for.
Okay, good.
Like they're contacts, they're not necessarily even complaints. They're called inquiries and
Okay,
complaints.
well, as long as that's spelled out.
Yeah, and I guess, for us, we might be taking it for granted because we've been doing this for so long. And we do it with over 500 different government agencies. And, and it just seems to work.
Yeah.
And of course, if the media called and said, look, you have 100 complaints here from Brian, originally they would say, oh, okay, 96 of those we found to be frivolous. So if it came into the public domain, then we certainly be front and centre and explaining what's wrong.
Okay. Thank you.
Councillors Badaway and Councillor.
Well, thank you, Mr. Chairman. And I do want to extend my appreciation to at least three of the council that asked the question about the costs of which the Ombudsman Office would otherwise have for the province of Ontario. Now, however, we do add into that pot as taxpayers of Niagara into the province of Ontario. However, I think what we're trying to recognize here in comparison to LAS is the cost to Niagara taxpayers. And my question goes right to that, is regardless of whether we choose you as a default service provider or not, your budget's not going to change. Your budget will be the same. Okay, so regardless, the Niagara taxpayers are still going to be paying for that service. And if we then hire LAS, we're going to be paying again. Thank you. And just a comment, Mr. Chairman, I want to make before I close out. I do appreciate, once again, that what you're doing here, you are adding the Ombudsman's Office, or even LAS for that matter, are being given the opportunity to add some teeth to an otherwise toothless tiger here. The only problem that I have is twofold. One, as I mentioned, as well as Mayor Bentley has mentioned, is the fact that some of us mayors we want to bring everything up front and center. Everything. The problem that we have is what happens if we bring too much up. I've instructed my clerk, and my council has a desire to bring everything up in the open. We have no problem with that. We think that's a good way to conduct. The problem is that what if we bring too much and what are the repercussions from it? The second part of it is, it's unfortunate, as Councillor Zimmerman was alluded to, under Section 14.1, that you don't have broader powers to, in fact, investigate other, I'll call them wrongdoings, within both government, whether it be the administration or the governing aspect of it. That's an unfortunate part, that your mandate's only this big versus being this big. And I do sympathize with some of the answers that you're coming out with, being as vague as they are, because you are into this for the first time, and there's probably a lot of other questions that are going to be asked that you're going to have a tough time answering because of the fact of that small mandate that you had. I was under the impression, quite frankly, that the Ombudsman's Office has always been traditionally an office that you can go to when you have a problem with government. Unfortunately, that is being told to me today that that's not the case. Your mandate is very slim to none, quite frankly. You're dealing with this only closed-door meetings. Once again, Mr. Chairman, I do want to make the point and emphasize the fact that that's too bad, because there's a lot more that can, in fact, come into your office in terms of complaints by both a governing, administering, even the public for that matter. We have no one to go to when we want to put teeth to those things that are otherwise in codes of conduct, in the Municipal Act, regulations, at whatever level of government. And that's unfortunate. And it's just too bad that you can't bring that message back, or I would just hope you would bring that message back to the office of the Speaker, of which you're a feature of, or in fact the Office of Municipal Affairs.
I think we'll certainly take that message back to the Ombudsman.
Thank you. Thank you, Mr. Chairman.
Councillor Sassy.
Thank you again, Mr. Chair. I'd just like to, if I may, categorize what's transpired. For the benefit of Mrs. Ray and Mr. Jones, I think some municipalities have been questioned as to why they would engage the services of LAS at a fee when maybe it appeared as though your costs were, as Wendy said earlier, free, which we know they are not free. I think that, if I may say, and this is why we're trying to get back to the element of cost to the taxpayer, I think there was some comfort by a number of municipalities who engaged LAS, knowing that they represent They're dealing through the Association of Municipalities of Ontario, which represent well over 400 municipalities in the province. And that there is some comfort in knowing that AMO understands the municipal creature. And I think unfairly characterizing anybody else other than the Ombudsman as being a cost to the taxpayer, when there is truly a cost to your service, even though it's being absorbed by the province at this point, it would still be imperative for us to point out to the taxpayer, yes, you're already being saddled with a budget commitment of $9.7 million for the cost of the Ombudsman in general operations. And yet you want us to consider then, are we duplicating services again by hiring LAS at additional cost to the taxpayer? Well, there is cost involved to as you say, to justify or to deal with each of your complaints that you deal with through the Ombudsman office. And that's why we're trying to get a handle on what you would bill out one of your staff people at is on per diem or whatever. So to truly be fair to LAS and anybody else providing that service, there is a cost, as you admit to us, Mrs. Ray, with regard to what you do. And I think that is what we're trying to get our head around, at least I am, because I feel that there's comfort in dealing with a company like LAS, which is a non-profit organization, even though there's a cost attached to it, but there's a certain amount of comfort knowing that they understand the municipal creature, knowing that you act in general at arm's length from all those municipal bodies, and certainly we understand that as well in your position. So I still have to say to you, our challenge here today, at least mine is to determine what value or what cost you would be attributing to each of your investigations, because it isn't free, as you said to us earlier. You corrected yourself. There is a cost associated, and we know that it's a budgeted cost on an annual basis. And I guess what we'll see if there's this balloon of inquiries, you will see a request come back to the province to increase your budget, and you have to obviously justify it on some basis for what you do. But what I'm trying to point out again is to emphasize we're comparing apples to oranges. We do have costs associated with both processes, whether you're the default investigator or whether we retain the services of private companies.
I think what we've said is that our services, when we say our services are free for people coming forward to use our services. Number one. Number two, we have a $9.7 million budget, and we are not planning on asking for any additional funds to do this work.
Is there any other questions of the delegation? Seeing none, thank you very much for your presentation. Appreciate you showing up.